Hello, my name is Kevin Thompson. I'd like to welcome you to the Davis McGrath LLC IB webinar series for April 4th, 2012. Today's topic is copyright ownership issues. The recording and slides will be posted at our blog, which is shown at the address on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our mailing list. For those of you who need Illinois MCLE credit, this should qualify for a half an hour of credit. And if you're interested in getting the credit for viewing the live presentation or for viewing the recording, please send me your name and your ARDC number if you haven't already done so. Our next webinar is coming up on May 2nd, 2012 on the trademark clearance process. Certainly looking forward to doing that. Today we're going to cover for about 30 minutes some interesting issues relating to copyrights, talk a little bit about copyright basics, go through the rights of the owner, just who is an owner, go through joint authorship, works made for hire, transfers, recordation, and an issue that's coming up more often these days was termination of transfers. Copyright basics, for those of you who are interested, our webinar on the topic of general copyright issues is available on the address on your screen here. Just in general, for a recap for those of you that haven't seen that, copyright protects original works of authorship. Once works are created, they are automatically granted copyright protection as a matter of law. They have to be original, and they have to be works of authorship that are fixed in a tangible medium of expression such that they can be later perceived or viewed. So once that's done, such as you've written a piece, you've saved it to your computer hard drive, you have copyright in that particular piece. It's a very interesting area. And there are certain things that are eligible for copyright protection and certain things that are not, such as the general idea of something is not protected. It is the expression that's protected. But we covered that in a lot more detail on the webinar on copyright basics, which I certainly would direct you to if you haven't already done that. Today we're going to go much more in depth on just, authorship issues as to who is the author and issues along those lines. Once you have a copyright owner, there are certain rights that the copyright owner has, such as the right to reproduce the work, the right to prepare derivative works, to distribute copies, to perform the work, to display the work, and for sound recordings, the right to perform work publicly by means of a digital audio transmission. So those rights are dependent on being the owner. And you have to be the owner to have these exclusive rights. So who is the owner? Normally the default is that the author of the work is the owner, unless there's other operations of law or contract where you've assigned those rights to another. There's some exceptions to that, which we'll get into. But generally, the owner is the author, the person who put forth the creative effort and made the work original. It should be noted that copyright is separate from the physical object. So if you own a piece of art, you don't normally own the copyright to the work itself. That generally remains back with the artist. So you may own a print, you may own a book, you may own a CD, but that doesn't give you the copyright interest in the underlying musical work or artwork or composition that is embodied in that physical object. An interesting issue that comes up a lot is an issue of joint ownership, and the 17 U.S.C. 101 is the definition section of the Copyright Act. Lots of good definitions throughout there. The definition that's given there for joint ownership is a work prepared by two or more authors with the intention that their contributions be merged into an inseparable or an interdependent part of a unitary whole. this most often comes up with works such as a musical, in which you have one author who creates the lyrics, and you have another person that creates the music, and their intention is that their lyrics and words be merged together into this musical at the time they create it, and so they would have joint authorship. What's important here is that what controls is the intention of the authors at the time the work is made. So if you have somebody who creates a set of music, and later on somebody creates a set of lyrics that's independent at like a different time, then it's not joint authorship. It's what's called a derivative work, and we'll cover that in a few minutes. The authors of a joint work are co-owners of the copyright in the work, unless there's agreement to the contrary between them, which means, quite interesting, that each has an equal undivided interest in the rights, so that one of the authors could give permission to do certain things without necessarily involving the other author. But it should be noted that exclusive rights, such as the right to distribute copies or to perform the work publicly, requires an agreement between the joint owners. Duration is the life of the last surviving author plus 70 years, which is slightly different than a standard work, which would be just if it was just one author, it'd be that author's life, but it's the last surviving author plus 70 years. Now, derivative works are what I alluded to before, when works are not necessarily created temporally at the same time. Again, the definition section of the Copyright Act, it's a work based upon one or more pre-existing works. And the examples given are translations, musical arrangements, dramatizations, motion picture versions, and so forth, in which, or there's any other form in which a work may be recast, transformed, or adapted. And derivative works are the most common way of discussing a work where it's based on a work that's pre-existing. So the example I gave earlier would be somebody who creates a set of music, and then later on somebody comes along and creates a set of lyrics to go with it. Then the lyrics would be a derivative work. It also could be an author's written a book, and somebody comes along and translates that from the original English into Swedish. The Swedish translator would have an independent right to their creative work, which is based on the derivative, based on the original. It should be noted that the original author has rights only to his or her work and cannot reproduce or perform the derivative work without permission. So that the example I gave is the Swedish translation. They have right to their work, but they wouldn't have right to the English original, and they still require the permission of the original owner to distribute their work. And then each author owns their own individual contribution, so that the translation will be owned by the translator, and the original book will be written by the author. It will be owned by that author. Another interesting piece that comes up is collective works, such as an anthology or other work in which you have a collection made of works. An example might be you have a series of short stories that a bunch of different authors have written, and if you decide to take that series of short stories and put them into a collection that you'd publish, you could have a copyright in the collection, but each author would keep their own copyright. so that each individual author could still authorize their work to appear in other places as well, unless there's an agreement that says that they won't. But let's say, each individual author still wants to, put their work into other collections, or to put their work to be published like on the Amazon Kindle store, or some other, method of independent distribution. And the ownership of each piece is separate from the ownership of the whole. So the ownership of the collection would be the person that put the collection together would have a very, very slim copyright in the fact that they have this collection of these works, as opposed to each individual piece. One situation that comes up we should talk a little bit about is what happens if the author is a minor. Minors can own copyright, but the laws regarding business deals with minors vary from state to state, so it's difficult to provide a uniform answer to this question as to what happens. In Illinois, generally a minor can own property, but needs an adult guardian to sign a transfer of rights. This is especially important if the author is giving away one of the exclusive rights. In also certain circumstances, it's appropriate for the property to be held in trust by a custodian. That also might be prudent if you are entering into a very large business deal with a minor, that you make sure that the person who is the adult guardian that's signing actually is a guardian, isn't just a parent. Parents don't always have the rights to sign away the legal rights of their children unless they've been appointed as a guardian. And it's important to certainly dot the I's and cross the T's and so forth, and properly make sure that the person that's signing the agreement has the right to do so. Now, works made for hire is another special situation that we'll spend a good amount of time talking about here today, because it's the one that comes up a lot, and it especially comes up in situations of works made by an organization or employer. And this is one where often people are tripped up because their expectations as to what happens doesn't always comport to what the law actually does. And the way the law works is that copyright in works that are prepared by employees in the scope of their employment are presumptively owned by their employers. And the important part here is that it's got to be an employee, and it's got to be in the scope of their employment. So if you have a work created by someone inside an organization, such as a person who's normally in charge of preparing a newsletter, that newsletter would be presumptively owned by the employer. Now, this would be different if the person is an independent contractor, which happens a lot these days. An independent contractor, normally the copyright would be owned by the contractor and not the employer, which could be important if the contractor is doing some sensitive work or work that is intended to be owned by the company. And if you do intend otherwise, a contract needs to be signed to explicitly state who owns the copyright and transfers the copyright if necessary. And works made for hire, a works made for hire agreement will only apply to certain type of works, which we'll talk about in a minute here. So here's the section of Section 101, again, the definition section. The first part is the first one we've talked about, a work prepared by an employee within the scope of his or her employment, or part two, a work specially ordered or commissioned for use as, and these are 9 specific examples that are given in the Act, And it should be noted that there isn't a catch-all language in this section. These are the only 9 things that are designed to be works made for hire. So a contribution to a collective work, a part of a motion picture or other audiovisual work, a translation, a supplementary work, a compilation, instructional text, a test, answer material for a test, or an atlas. And so even though you may put forth in an agreement that you believe what you are doing to be a work made for hire, if the work that's contemplated doesn't fit in one of these 9 categories, then it isn't a work made for hire under the definition of the Copyright Act. And so even though you may have an agreement that says it is, it really isn't, and as a result, that section could be considered void in the contract, and the person who actually did the work would be considered the copyright owner, if that was ever put to the test. And so one question that often comes up is when you're dealing with a situation with someone that potentially could be considered an independent contractor. It happens a lot these days for tax reasons or benefit reasons. Companies will hire somebody on for a special project, and then when the project is over, that they're done. Was that person an employee during the time period that they were there, or were they an independent contractor? And it's sometimes an important fact question that a court will look at to see whether or not it is a work made for hire. And some of the factors that we'll look at is how much control did the employer have over the work? Did the employer direct it? Did the employer create it, or was it totally under the work of the employee? Or the worker. We'll say that here just to avoid making it seem like we're picking one side or the other here. But I mean, the worker, were they an employee or were they an independent contractor? And did the employer give directions as to what the way the work was supposed to work out? That's one part of that first factor. The second factor is how much control did the employer have over the worker? Did they direct their actions? Did they say, you shall work here, you shall only work within these hours, you shall, only work on this particular project for me? How much control do they have? And then, what is the status of the employer? Did they provide benefits? Did they deduct taxes? Did they do the other things that normally would be done for an employee, as opposed to somebody who was independently working for the company? And so it's a very highly fact-specific question here. Some examples here of work made for hire agreements or situations where this can come up a lot. So if you do have these types of works done by independent contractors, it would certainly behoove a careful look at the arrangements you have with them. Website developers, you may have worked with someone to create your website, and if you don't have a transfer of copyright ownership in the arrangement, you quite easily could not actually be the owner. Same for computer software. Again, neither one of the website or computer software is one of the the 9 categories. So certainly it would be prudent to look at the arrangements you have. Photographers, if you've got someone that takes pictures that you put up on your website or in your publications, that certainly it would be prudent to look at. Graphic artists, if you have somebody that creates a logo for you, or someone that creates some other design elements that you use in your business, again, it's important to look at those types of contracts. But at the same time, you have brochures or publications that are produced in-house by your employees. Those would be presumptively owned by the employer because, you know, if they're produced in-house by an employee within the scope of their employment, they are presumed to be owned by the company. Another example to take a look at would be an agency you're working with to produce advertisements. If you don't have a you know, particular arrangement with that agency as to, you know, who owns what, and if they don't have like a specific transfer in place, you may not own the creative work that you think you do. So as a practical tip, personally, I like to practice a belt and suspenders approach, and I like to have a written agreement in place that asserts the items are intended to be a work made for hire, but in the event the item is deemed not to be a work made for hire, then that particular agreement functions as an assignment, and you know, puts forth a requirement if necessary for, you know, people to work you know, to sign whatever might later need to be signed in order to, you know, effectuate, you know, that intent. Now, transfers is the next topic we'll be talking about. Is you know, to have a this would be the part we're talking about agreements in place or other operations, you know, there's some specific rules that take place, you know, depending on just what it is that is being transferred. Now this is the most common, which is transfers by agreement, which you have a contract in place with someone to transfer copyright ownership. Any or all of the exclusive rights can be transferred, and you don't have to assign all of them either. You can assign one person the right, one of the exclusive rights. So this is just the right to perform the work publicly can be given to a theater. But you also may have the right to distribute copies of the work, such as a play. You might send that off to a publisher who can then create a book. You might authorize a translation, which would be a derivative work. So if you want the work to be performed by you know, company in Sweden, for example, the Swedish translation could be an authorized derivative work to a yet third party. And the important part of this is that a transfer of copyright ownership must be in writing and signed by the owner. And a transfer of one of the exclusive rights must be in writing. But if you are giving a non-exclusive right, such as something where you're merely granting someone permission to do a certain thing with your work that doesn't impact one of the exclusive rights, you don't need a writing. Those types of things can be done orally. But if it's any one of these other things, it must be in writing. There are many courts these days that say a writing can be done electronically. So if you've got an email giving a transfer in which you know, it's acknowledged by some form of digital signature, then that certainly could potentially be enforced. Again, it'd be a sort of a fact-specific question here. And it's important to note that there are other ways that copyright can be transferred, such as operation of law. And a question that comes up a lot is what happens to your copyrights when you die? You know, what happens to those? Is it something that just disappears after your death? And the answer is no, because the way copyright is structured is that the right, like the right essentially is measured by the life of the author. So the work is anticipated to end at a certain number of years after the author's death, and although the number of years seems to get extended a lot by operation of law, it's currently the life of the author plus 70 years for basic general protection. And so you know, it should be noted that what happens to that work is it's a copyright is a personal property right, which can then be willed or passed on with personal property as part of an estate. And so you may have a will that functions as a transfer device. You may have probate that functions to transfer the personal assets as part of an estate. So those are all ways in which these works can be passed along. It should be noted that when you register your works at the Copyright Office, you can also record a record an assignment or other assignment of rights, or a license perhaps could be recorded at the Copyright Office. So there's no requirement to actually do record these things, but there are some benefits that you get by doing so. It puts people on notice of your rights, and you can establish priorities if there are any conflicting transfers. You might want to do that so you've got people would have what's called constructive notice of your rights. You record, and if there's ever a dispute as to who's properly the owner, you can say, look, as of this date, I was recorded as the owner, and you're constructively presumed to have known that as of the date that I filed this with the Copyright Office, and which then is a publicly searchable database of ownership. An issue that comes up a lot these days is when you do have an assignment of exclusive rights, is there any way to say, geez, I got a bad deal to get a work that I gave the exclusive rights for, but nobody's publishing it, nobody's doing anything with it. What do I do to get this back? There are certain ways in which you can terminate the transfer. The right begins 35 years after creation, and it lasts for a period of 5 years, and you have to serve written notice of termination. But it's important to note that if it's a work made for hire, you cannot terminate that. That simply it's not allowed. But if you've got a work in which you as an author gave a publisher certain rights, and for whatever reason you want to get that back, either you or your estate can bring these termination proceedings. Again, there's a 5-year window that begins 35 years after creation. And these are certainly in the news. What you're starting to get is certain popular music recordings that were created after 1978. They're starting to become eligible for termination in 2013. And what makes that interesting is that before 1978, certain types of sound recordings were not eligible for copyright protection, and so what ended up being the case is that's when these rights began, these certain popular musical artists are starting to look into it. There's I believe Bob Dylan and some other artists are certainly looking at seeing what they can do to terminate. But it's by no means a slam dunk because, as I mentioned before, works made for hire are not eligible for termination, and the question would be for many of these things as to whether or not they're actually were a work made for hire, because some of these artists would have been under contract with the recording studio, and just what impact does that have? And so both sides, the artists and the recording studios, are certainly going to be battling these issues out. You're probably going to be reading some more of these issues in the next few years as these works are starting to filter the way through. And there was a recent case that was just filed, the estate of Ray Charles with his children. I didn't list them here, but I believe there was about 7 of his children which are part of this. Essentially, just very briefly, when Ray Charles, before he passed away, he'd set up certain irrevocable trusts for each of one of his children with the condition that they do nothing to contest the rights in his musical library. And they wanted the musical library to be owned by I believe it's the Ray Charles Foundation. And his foundation is suing the children because some of these children have decided to try to, get more than what was given as part of their his estate planning, and are starting to try to terminate the rights of the transfers that were done. And it should be a really interesting issue. We'll see how that pans out. But the case was just filed just a few days ago. So that's a good point to see if anybody has any questions at this point for what we've talked about so far. If you do have questions, please feel free to use the software. The webinar software here has a procedure where you can input a question for Nat, and I can answer it very briefly. Also, if you have questions, if you're watching the recording, you can send them to me by phone or email. I believe I just saw a hand raised. Is there a question? Question is, can you tell us more about the Ray Charles case? I'm not sure what more details you'd like to know. I don't know too much more beyond the specifics. I've read a copy of the complaint when it was filed. And if you want to send me an email at my address below, which is kthompson@davismcgrath.com, and send me your email address, I'd be happy to reply back with a copy of the complaint as filed. Are there any other questions? Well, if there are no more questions, I'd like to thank everybody for attending. Again, our next seminar is coming up on May 2nd, 2012 on the trademark clearance process. Again, you can sign up for our mailing list at blog.davismcgrath.com/webinars, where also this particular recording will be posted. And again, if you need MCLE credit for Illinois, please send me your name and ARDC number if you haven't already done so for viewing the live webinar or for viewing the recording. And so I'd like to thank everybody for attending. Have a great day.